Sexual assault offenses are among the most awful crimes listed in the criminal code. And for victims, they can be even more awful to take before the courts. Joining us now to examine how the criminal justice system deals with these cases and whether it's time for a new approach. Marie Corbett, she's a retired Ontario Superior Court judge and author of January, a Woman Judge's Season of Disillusion. Breece Davis, criminal defense lawyer with Breece Davis Law and vice president of the Criminal Lawyers Association. And criminal lawyer David Budd is here, and he routinely represents sexual assault victims in his practice. And it's good to have all three of you here. Thank you. The second time.
Yes.
Nice to have you back.
Pleasure.
I want to just start by following up on the interview we all just watched, and that I did, obviously, with Lori Haskell, and see what's worth following up on based on your reading of what she had to say. Marie, would you start us off?
Thank you, Steve. It's a pleasure to be here. What the Professor Haskell said is extremely informative. And in terms of, obviously, the effect on victims, as a judge, I have no quarrel whatsoever with that. I think it is very difficult for judges to take into account feelings because judges look at acts and statements, and they look at how the person is feeling based on their actions and statements.
All right. Do you quibble with anything she had to say? You violently disagree with anything she had to say?
Well, there are a number of things that I disagree with, and a number of things she didn't address. For example, there's the effect of memory. How the event occurs, and it only gets into court a long time later often. Right. And so a lot has happened in the meantime. So how does memory affect the experience of sexual assault? And how does memory affect the relating of it in a court of law? And it's unfortunate that a lot of sexual assault trials or any trials take a long time to come to court. And we wonder what happens. I did describe, for example, a case in my book of a 16-year-old girl giving evidence. And I described that she had a wooden effect that was completely in accord with what we heard about psychological conditions. And I actually said in the book, well, it's probably not surprising because she's probably told the story or what happened to her to a mother, an aunt, a relative, a social worker, a teacher, a police, and so finally she's wooden. What about the effects of the passage of time? And I'd like to say a little later that I think there's an evidentiary rule that should be changed in order to accommodate that problem.
Okay, we'll come back to that. Breece, how about you?
Well, a lot of what Professor Haskell said is really important for the criminal justice system to understand. All the players in the justice system, defense counsel, crowns, police officers, judges. It's important for us all to understand how trauma affects one's ability to create memory and also to retrieve it after the fact. That's very important. I think the concern I have with what she said was the notion of starting from a presumption of believing people. Obviously, people who have experienced trauma should be believed. Their experiences should be validated. I agree that police and people dealing with victims need to be compassionate and need to be kind and need to be understanding in their approach. I don't know that that needs to translate into the criminal justice system where the result at the end of the day is someone's liberty can be taken from them. They can be criminalized, they can be labeled as a criminal, they can have a criminal record permanently. So I think we have to be mindful of the different steps in the process and the outcomes of those steps when we're thinking about how to deal with information and how to get the best information to make good decisions at the end of the day.
I suspected this was going to be a point of departure between her and you.
Yes.
And how do I ask this question without coming off like a male chauvinist pig? Do you feel you're letting the sisterhood down by evincing that position?
I don't think so. I think people need to be believed when they say they have been the victims of trauma.
But not necessarily to a legal standard that would put somebody behind bars.
Right. I mean, if I was a victim of trauma, I would want everybody in my support circle to believe me. If I wanted to complain to the police, I would want them to treat me compassionately, and I would want them to be understanding of what I say I've been through. That doesn't mean that when I come into a courtroom, I have a presumption that I am telling the truth. Although, quite frankly, legally I do. When people take an oath, they are presumed to be telling the truth unless there is some evidence that would suggest that they aren't. So I don't think that the structure of our system has to change. I think we need to focus on making sure that everybody in the system understands how complicated these experiences are and how they affect people. And with that knowledge, I think will come a change in people's approach and will come a change in people's understanding. And we will evolve as we've evolved with child witnesses and other types of witnesses that present different evidence in a different way than we may expect in some cases.
Okay. David, your view.
Yeah, just to integrate into the discussion my thoughts on what Brice has said, always very, very thoughtful. And of course, what we've heard from Dr. Haskell. There are a lot of things about which Dr. Haskell has spoken that I agree with. And I may depart a little bit from Brice in saying that first of all, I agree that there does need to be a much more sophisticated integration of understanding of the neurobiology of trauma into our criminal court decision-making processes. How do we do that? The answer in my mind, Professor Haskell spoke about the limited education judges have. Well, there's a really important ongoing opportunity, and that's called expert evidence. So I think that in every case, regardless of the experiential background of the judge, where evidence on the neurobiology of trauma would contribute to a more sophisticated understanding of the events before the court, responsible experts should be presented to assist the judge in making their decision. So I think that's a great point she has, and to my mind, there's an avenue that's underutilized right now that should be.
And you think that would overcome the apparent lack of training and experience that a lot of judges have on these kinds of cases?
Yes, I'm going to respectfully disagree about my experience with the judiciary as a practicing lawyer for 30 years is that by and large we have a stellar judiciary. And I am going to say that of course there are shortcomings and it's the bad apples that get all the attention, so there's perhaps a misunderstanding amongst the general population about the truly high quality of judges that we have, generally speaking.
But well, I shouldn't say you'll acknowledge. Would you acknowledge that for somebody who's been an entertainment lawyer for 25 years, who with no training in sexual assault cases suddenly finds himself a judge presiding over that kind of case, that's not great?
I will say that there are weak performers in any organization of multiple people.
That is true.
And but I will also say that sometimes the criminal lawyers who become judges are the weak performers in criminal cases, just because they have years and years of embedded assumptions, practices, and they're just doing the same old thing every day rather than challenging themselves. And I think that's where the expert evidence is so important. As our understanding evolves, we really do need to ensure that judges have the tools to respond in a more sophisticated way. If the science tells us this is what we should be thinking about, gosh, let's start thinking about it in a courtroom.
Since we have an ex-judge here, I think I'm going to put that to her. When you handled these kinds of cases, when you were on the bench, did you, in the main, feel that you had the training, experience, understanding, sensitivity, etc., to deal with them to the satisfaction of the justice system?
I had not done criminal law as a lawyer. I had worked for the City of Toronto and prosecuted bylaws, which is not the same thing. But when I was appointed to the bench, I wanted to pursue criminal work. And I started off slowly. We only had 2 weeks at a time, and you start learning. Judges also get education in all kinds of courses on an ongoing basis. So, of course, I studied criminal law because I wanted to do more and more and more of it. And I trusted my own personal judgment and my own common sense. And I also knew that what I didn't know. And there's huge resources in a large court that you can take a break and ask other people for advice, because there's often motions or problems come up that you need an instant answer to. And if you're in doubt or you're not sure, then you can always step back and ask somebody else. But I do recall when I was first appointed or started doing criminal work, including sophisticated and complicated wiretap applications, that defense counsel would look at me and say, well, as your honor well knows. And of course, I knew her honor didn't well know, and they knew that her honor didn't well know. But that's part of the learning curve. And I do agree that people with other than criminal law experience should be in the criminal courts. After all, look at juries. I mean, they are judges in the course of a trial, and we value their input and their common sense.
But as you discussed cases, as I assume judges do when they're in chambers or just in casual
Yes.
situations with your colleagues, your fellow judges, as you discussed cases, what was your level of confidence that the judicial system, that your fellow judges had enough of an understanding and sensitivity about how to handle these most difficult cases?
I think there's always room for more education, especially at this time when sexual assault is such a difficult problem, when 6% of sexual assault cases are reported, 1% to 2% of date rape cases are reported, and we have to look at why that is. The criminal justice system is not serving sexual assault victims, and it has to become more compassionate and has to be more respectful. I put a lot of the problems at the foot of cross-examination. We are not going to change the standard of proof at all. Why should we? It benefits all people. It benefits us in a wide variety of circumstances, from traffic tickets to zoning infractions, regulatory offenses. We need that burden of proof. We need the presumption of innocence. We need an accused person to have a fair trial. But we have to go further. We need the victim to have a fair trial as well, and a respectful trial, and some victims are not having that. And I attribute that to cross-examination, which is the method by which trials are conducted and witnesses give evidence.
Let me follow up with Brice on that, because I want to know, this seems like an impossible mission. For a defense lawyer to adequately represent his or her client, who potentially is facing the loss of his liberty because of allegations made and charges brought, while at the same time respecting the experience that a presumed sexual assault victim has to recount on the stand. How do you walk that tightrope? It sounds impossible.
Well, all lawyers are bound by rules of professional responsibility. There are limits to what defense counsel are permitted to do during cross-examination, both in terms of the content of what we can ask about. There are, as we have learned things and as we've come to recognize stereotypes, we have made certain areas of inquiry impermissible. You can't, for example, ask sexual assault complainants about their past history of sexual behavior.
It feels like you get that in somehow, right?
No, you don't.
Well,
you need an
am I watching
application.
too much TV?
I think so. You have to bring an application. You have to get the judge's permission to do it ahead of time. You have to lay out why you want to do it. You have to lay out why you say it's relevant. It's a relatively high threshold to do it. And if you don't have prior approval, you cannot do it. So there are limits on what you can ask. There are also significant limits on how you can ask questions. You're not entitled to be abusive. You're not entitled to be, oppressive with a witness.
How about dismissive or snarky, or because there's been certain high-profile cases where that seemed to be the case?
Look, just like we've talked about judges, there are going to be lawyers who cross over the line and ask improper questions, either in terms of the content or the manner in which they're asking it.
Do the judges call them on that behavior?
They do, and the Crowns object, and they should. That's how the system works. It's a human system. So in the course of an adversarial process, everybody steps over the line from time to time. Crown asks improper questions of accused people when they testify. Defense counsel sometimes ask improper questions of complainants, and that's why we have judges to be intervening, and they should do that, and that is the proper functioning of the legal system. But to suggest that there's sort of rampant disregard by defense counsel—
Not the case.
It's not my experience at all. I think defense counsel take their job very seriously. They take their obligation to their client seriously, of course, but they also take their obligation to the court seriously, to act in a professional manner, properly prepared, acting within the rules that exist.
I, David, with you, want to follow up on something that Marie just mentioned a while ago. She gave a kind of litany of statistics about what's happening out there right now. And I think we should put this up. Sheldon, let's put this graphic up, because I think people just don't know that, in fact, sexual assault is far more common than most would suspect. There are relatively few incidents of sexual assault reported to the police. Young and otherwise vulnerable women are most likely to be sexually abused. And most sexual assaults are committed by somebody close to the victim, not a stranger. That's sort of what you'll find if you look online. That is what the major research organizations tell us is the case. Anything you want to quibble with there, or anything that you find doesn't fit with your understanding of things?
Not at all. That's entirely consistent with my understanding, and it speaks to a bigger problem. And here's where I'll respectfully part company with Breeze. We have a lot of fun doing this, and I admire her a lot, but I'm going to disagree strongly with one thing. To hear Breeze talk, you'd think the status quo is fine and everything's hunky-dory. They're the occasional bad actors, but that's the only problem we have. Actually, we have a much bigger problem than that. If you think of this in terms of service delivery, and you listen to Marie's accurate statistics about underreporting and underparticipation, we are profoundly failing to serve the victim community with the criminal justice system. And my response to that thesis, we've been tinkering with it for years, getting rid of questions about prior sexual conduct and so on, and the reporting rates haven't changed. I say, after 30 years of reform in a tinkering fashion to the criminal justice system, we need to think more bigly, if I can use that word.
And the reporting rates haven't changed because people still assume that they're going to be put through the meat grinder when they come to court.
Exactly right, and we're still creating a process that is traumatic for victims. So I think we need to, without abandoning fundamental precepts like the presumption of innocence and proof beyond a reasonable doubt, we need to recreate a courtroom that is more sensitive. But we also need to think about whether in some cases there are alternative methods that don't involve the criminal justice system. And people may criticize me for saying, well, you're treating sexual assault less seriously. I say no. If we listen to the voices of victims and give them a healing journey and validation in alternative methods that work for them, then we are actually treating sexual assault more seriously.
I do want to pursue that, but I feel I need to give you an opportunity because I don't think you ever said you're defending the status quo, but so you want to take him on that?
Well, I think there's a lot of things we have to ask ourselves about sexual violence and why it's not being reported at the level of some other crime. First of all is, what are the barriers to people coming forward? There are lots of steps in the process before it ever ends up in a trial. In fact, there are lots of criminal matters that resolve without any trial at all. So are the barriers at the reporting stage, sort of at the interface with complainants and the police? Is the barrier the interface with the justice system? Is the barrier the trial itself?
You want to give an example of this?
Well, I don't think we know why it is complainants are deciding not to come forward. Is it that they don't feel they're being listened to by the police and that the interview process with the police is not sufficiently compassionate and understanding?
Well, we can come to some pretty good surmising about why people don't come forward, can't we?
I don't think we can. I don't think we can say it's the process of cross-examination 2 years down the line that's what the barrier is to people coming forward. I don't think we have a good understanding of that. And I'm not sure we have a good understanding of how many people who have been the victim of sexual violence want to come forward and are not doing that. That's an important question. People get victimized in all sorts of different ways. It's not right. It shouldn't happen. We should actually be focusing, in my view, our attention on preventing sexual violence in the first place.
Sure.
But people get victimized in lots of different ways, and they choose to come forward or not for lots of personal reasons. And I think what we need to know is, why are people choosing not to come forward? Are there systemic problems within the justice system that stop people from coming forward? What are they? And I agree, if there are problems, we have to address them to the extent that we can without compromising an accused person's fundamental rights.
Okay. Good questions. You want to try answering some of them?
There's a lot there. I think women do not come forward because they're not treated with respect. When they do come forward on sexual issues.
Not treated by respect by whom?
Throughout.
Police, courts, media.
Yeah, well, there might
public.
be, in general, yes.
General.
And cross-examination is brutal. It is absolutely brutal. It can be humiliating. And I do not believe that judges are sufficiently interfering and controlling with it, because the Supreme Court of Canada has said cross-examination is one of the best techniques to ascertain truth. I simply do not agree with that. And women do not wish to come forward and have all kinds of aspects of themselves scrutinized in perhaps a bullying and brutal way. Second, it's an adversary system. It's one against the other. When really it's a tripart kind of thing. It's society, the interests of society, it's the interest of victims, and it's the interest of the accused. And quite often, I think that Crown attorneys are not active enough in containing bullying, cross-examination. Witnesses can be cross-examined on minutiae of something that might be allowed, when perhaps a simple statement of agreement, yes, I did say that earlier, or that sort of thing. And cross-examination on inconsistencies gets to be grotesque on every little thing. Oh, you were wearing pink pajamas, not blue. And then at the end, every little discrepancy is like a dartboard that somehow you have attacked this person. Who wants to go forward and do that?
Do you think the Ghomeshi trial set back the cause of more women coming forward because of the way all of the public details of the women were put on display?
Ghomeshi was extremely unusual in terms of a sexual assault case. First of all, every single woman consented to the sex. Well, that's not what we're talking about. What didn't they consent to? Assault. Why couldn't he have been just charged with assault, and then you wouldn't have to go through? Well, what kind of sex did you have then? Did he pull your hair before or after? Oh, didn't you say he pulled your hair against the car another time, or whatever it was? Why wasn't it a simple assault case? Who objected? They liked the sex. So that can't be used as kind of a bellwether case in that sense, although it was topical and it brought up the pitfalls of cross-examination.
So, David, it did, if I'm hearing the judge right, it did set back the cause of women coming forward, because the witnesses, the victims, were put through the meat grinder in that case, alleged.
Yeah,
right.
the Ghomeshi case, and I agree with Marie that it was unusual in certain aspects. What is perhaps a little more typical is that it was full adversarialism on display. And I think, to Marie's point, it demonstrates that if adversarialism is our one-size-fits-all go-to to resolve these problems of alleged sexual violence, we are going to continue to underserve victims, and we are going to continue to overlook the nuances of truth that we need to be delving deeply into.
Let's go where you wanted to go a few minutes ago, which is to say, if there's a better way, can we kick around some ideas here about a better way to do this? What do you think?
Yes, I've written about this. I think that there should be a range of options for complainants who have real choice in the matter. I am firmly committed to the idea that the public prosecutor should remain involved, but there are some cases for which the traditional criminal justice system will be appropriate. Prison is an obvious need in a particular set of facts, and so you need a full adversarial trial with all the protections for an accused. There may be a range of cases where victims say, look, I don't care if he goes to jail. I don't care if he's on the sex offender registry for life. I want validation. We may be able to look at a publicly carried forward civil suit where the burden of proof is less. There's a requirement for the accused to get in the box and give his side of the story.
That's an option right now, though, isn't it?
Only if the complainant has the resources to fund it privately.
I see.
And when the damage awards are $50,000 for sexual assault and you have to pay your lawyer $250,000,
Right.
it's a non-starter.
Right.
So I say a public option where the Crown Attorney can sit down with the complainant and say, we could go civilly, we could go criminally. Here are the advantages and disadvantages of both. And then a third dimension to the different opportunities we might have would be a more sort of restorative approach. However that looks like, whether it's a healing circle in Aboriginal communities or something like it in other communities, people are exploring these issues of sexual violence, the social impact, the personal impact, looking at consequences in a more limited sense, but nonetheless sending a public message that this kind of behavior is wrong.
Can I just understand that? Restorative justice, would that involve the assailant and the victim being in the same room at the same time?
You could structure it any way you want. Sometimes in tough restorative processes. You have it's like shuttle diplomacy back and forth in rooms and so on. Will there be an acknowledgement and so on? We saw the nascent beginnings of that in the last Ghomeshi prosecution, where the prosecution peace bonded the case, but Mr. Ghomeshi also issued an apology. That, to my mind, was a sophisticated use of the current limited tools to try to move beyond just a purely winner-take-all strategy. The charge was withdrawn, but there was an apology. The complainant in that case was able to stand on the courtroom steps and say, here's what happened to me.
And she did. She quote unquote held court.
Held court.
Yeah.
So we see the players in that case groping towards some kind of resolution that is a little less winner take all. And in the context of sexual violence in a social relationship, where those relationships may be ongoing, that may well be, for some complainants, the best approach.
I got to get Brice on this. How much of that can you sign on to?
Well, I think when you're thinking about structuring different models, if we're sort of blowing up what we've got now and thinking about what's the best approach, you really have to ask yourself, what do you want the end result to be? And I agree with David to a large extent. If you want the end result to be punishment and the potential for jail, deprivation of liberty, stigmatization with a criminal record, I don't think we can do away with any of the procedural protections we have now.
So what can we add to it?
Well, but I also agree that some people don't want that. Some people want something different. We currently have a civil system. Complainants can sue people civilly. We don't have a well-developed sort of alternate restorative justice approach, but we have diversion available from the criminal justice system that could be more developed to be more restorative.
What does that look like?
Well, I mean, it could look like a sentencing circle, as David has suggested, of some sort, or some sort of mediated resolution system, which happens in other systems. The problem that I see with creating alternate streams of resolving interpersonal sexual violence is you can never guarantee an outcome. All we can do is design a process that is fair and respectful. So you can never guarantee to a complainant that she will be satisfied by the outcome of whatever process you put in place, whether it's criminal or civil or something else. And so then you have to ask yourself, well, if a complainant, presumably a new model would be complainant driven. The complainant gets to decide, maybe with the advice of counsel, which route they want to take. The problem is, what do we do with the outcome of that if the complainant is not satisfied? Can the complainant choose resolution, and if she's not satisfied with that,
Go back to court.
Then go to civil,
Yeah.
and if not satisfied with that because we have no statute of limitations, go through the criminal process? I think that's really problematic, and it's problematic for one important reason. Anything an accused person says to anybody outside of a courtroom is admissible against them at a trial. So if you want a restorative justice process where people have an open dialogue about what happened, educate an accused person about what happened in their experience and get them to understand it and come to some agreement, that's going to involve making comments and talking about what happened. And you have to do that in a way that doesn't ultimately jeopardize the accused. You can do it. You can do it. But I think there are a lot of problems that would have to be worked out to make sure.
Let me guess, I'm just running out of time here, and I want to say, do these problems hamstring inordinately your ideas of alternatives?
No, because I'll say I agree with Brice. I don't think somebody should have the option of being, I'll try this, and then I'll try this, and then I'll try that. That creates more problems than it solves. So there should be an informed choice at the beginning, and access to counsel to make an informed choice and so on is essential.
Marie Corbett, let me get you to weigh in on this notion that was raised in the previous interview of we can have an adversarial court system to deal with robberies and murders and white-collar crime and drugs and all that business, but sexual assault is a crime of a different nature. And we might actually be better off having just a completely separate wing of the courts, if you like, or division of the courts, dealing with only those cases where all of the issues that we've talked about here, added sensitivity, higher respect for the woman testifying, could be brought to bear. What do you think of that idea?
I think you could have a dual system. For example, we have crimes, which is federal jurisdiction, like criminal negligence causing death, and yet you still have careless driving under the Highway Traffic Act. I don't necessarily believe that it should be a civil system exclusively for certain domestic violence crimes. I think you could have regulatory offenses and a regulatory court, perhaps called the domestic violence court. Take out the word sexual out of it, and start it off with it's being available to assaults that occur where people are living together. For example, with children or spouses. Oftentimes, the people involved do not want lengthy sentences, and yet if you had another system provincial-wide, then you still had the opportunity to have a limited range of sentencing. You could be fined, or you might have 6 months or something like that. Not only that, if it's at the provincial level and it's people living together who know each other, there's greater access to the social services needed for remedial action.
Anybody suggesting this, or is this under discussion anywhere to your knowledge?
Well, the first time I heard about it was from David Butt, and so I've been thinking about it ever since. And something has to change because the criminal justice system as it is too big a mallet for what we're trying to do, where the people involved are people who know each other. I mean, if you are out walking on a street and some stranger attacks you with a knife and rapes you, well, that's the criminal justice system. You'll get DNA and whatever. This isn't what we're talking about here. It might be a husband and wife, and they've had sex all along, and then she doesn't want to have it. You know, you can't bring in all of the safeguards and the heavy hammer of criminal law in those cases when basically you're interested in a resolution. And so that's why I think that something equivalent to lesser offenses confined to certain situations, but still having significant penalties as opposed to being merely civil is a step in the right direction.
So we need alternatives. We need a different and better way of handling things. How much appetite do you think there is out there to try experimenting with something new?
I don't think it has to do with appetite. I think it has to be done. It's a social necessity.
But at some point where the rubber hits the road, the government has to make a decision, either we're going to do this or we're not. So how much political input is there behind this to make it happen?
Well, I would hope that there is a lot from, I think that a lot will come out of the report of the Canadian Judicial Council into the after the Justice Camp inquiry. I think it has been in the media on page 1 almost ever since the Gomeshi trial, and it hasn't gone away. And then not to mention the boys will be boys, and it's locker room talk that is also the subject of popular media.
I have never heard the expression locker room talk more than in the last 3 weeks for we know why.
Yes. But it's been there, you know, in the RCMP, in the military, we're talking about the lack of respect for women, basically, you know.
I've got 30 seconds, David. You take it.
Yes, I think that Marie is absolutely right. Action is inevitable because there has been, the statistics about underreporting have been around for decades, but it's only in the last couple of years that there has become widespread frustration and, dare I say, even fury with the status quo. And I think it's incumbent on our political decision makers to react to that new reality of we're not going to take this anymore.
I want to thank all three of you for coming in and having a very enlightened and civilized discussion about a very, very tough topic. Marie Corbett, the former judge, I hope we're going to see you on this channel again.
I hope so too. I didn't say all I wanted.
Well, we never do. We never do. There's only an hour. David Butt and Brice Davis.
Thank you.
Spelled Davies, but pronounced Davis.
That's right.
Just so the people at home know that I'm not mispronouncing your name.
That's right.
Thanks so much,
Thank
everybody.
you.
Really appreciate it.
Pleasure, Steve.
Help TVO create a better world through the power of learning. Visit TVO.org and make a tax-deductible donation today.